On higher education. Appropriations, we're going to consider LC 288394S, members of committee. These copies will be available after the meeting in the clerk's office as well. It may take them a little while to get them printed. We'll try to get some more copies for those who want. I think I've given copies to both sides, though, so that they can scan those and put them on your electronic media. Everybody should have access to it fairly quickly. Here's what we're going to do today. We've already had a long public hearing. We have rules at 9 o'clock this morning. This subcommittee is going to hear from Representative Regina Quick, the co-sponsor of this, probably the person who's done the most of the blocking and tackling and the serious work on this. Representative Quick is a attorney who's spent a good deal of time in this space as well, and has most particularly, she's responding to a significant amount of work we've done since the last meeting with the Georgia Network to End Sexual Assault, Jennifer Bivens, Representative Smyrie, others. I'm trying to incorporate the ideas of many of the people we heard last week or 2 weeks ago, and those who have come to me in the interim. I met with Holly Tuckman from Cobb County. That's our Live Safe resources there in Cobb. So we've gotten a lot of input over the last 2 weeks. So what we're going to do now, and I'm going to take two representatives from for and against, and we're going to keep it really short because we've got rules. 2 to 5 minutes, please, when you do testify. And I've already been given the two individuals from one side of the equation. That's Miss Lisa Anderson and Miss Michaela Haynes, and then there'll be Mr. Charles Jones. And since Representative Quick is pro, obviously being the co-author of the bill, so that'll be 4 total, and we'll go 2 to 5 minutes, and then I'll ask for a motion at that time. Representative Quick.
Thank you, Mr. Chairman and members of the committee. I appreciate your courtesy in allowing us to incorporate, and we'll do some additional work on the bill after hearing from some folks. And I'll walk you through the changes from the previous version that passed out of subcommittee with the do pass, but I'll be working from LC 288394S, which is before you today, referencing LC 288277S, which is the substitute that passed. On page 1, line 24 is the first change. The word reasonably has been inserted before belief to modify that. After some discussions with some folks from the private post-secondary institutions, it was felt that might tighten up the difference in just a rumor floating in the hall, so to speak, and something that actually had concrete information that they had been provided. So they asked for that tightening, and the chairman has included that. The next change came at the request of victim advocates, and you may recall Sheriff Berry's testimony from the previous subcommittee dealing with exactly how law enforcement handles the investigation. And you may also remember the discussion about the contents of a Clery Act notice. So there was some discussion about making sure that it was clear that this first report to law enforcement would be non-identifying as the Clery Act requires, and to make sure that the identifying information for the victim was not provided to law enforcement without consent. So that change is beginning at line 27 and going through line 29.
And also, Representative Quick, this came from the conversations we've had with Representative Smyrie. This is the portion that specifically identifies sexual assault from Title VI. Representative Smyrie, from one of the issues that you brought to me. So continue, Representative Quick.
The other addition to the bill is lines 35 through lines 37, and this is, in our view, it's a clarification, but in the view of many, it's a very important clarification that nothing we're doing in this new statute requires a victim of an alleged sexual assault to cooperate with law enforcement in the investigation or to participate in any subsequent prosecution. So we had a lot of testimony about that at the previous hearing, so it was felt that the best thing to do was just to state with clarity what was intended and what was not intended there. Now, you'll notice that these things I'm walking through apply only to victims of alleged sexual assault, and that is because the bill applies to all felonies that are committed by students or on campus from a campus reporting requirement. But because of the specific and unique nature of sexual assault claims and already existing legal protections for victims, it was felt that we would go the extra mile and make sure that we were trying to clarify any confusion that there seemed to be about the way we thought it would work versus the way people were afraid it might work. And so that is the change, again, line 35 through 37. The next change deals with interim measures that the university could take, and this is line 40 and 41. These two sentences were separated. They were formerly the same sentence and sort of blurred in some folks' mind. The distinction between interim measures, which we talked about at the previous hearing as being things like changing classes or changing dorms, and disciplinary actions, which are quite a different thing. And so those two sentences were separated. Lines 51 through 55 are also new text from the previous substitute. This provides a mirror protection for victims of alleged sexual assault in the disciplinary process to make it clear that the university can't, by its code of conduct, require the participation of a victim of an alleged sexual assault in any disciplinary investigation or require participation in that process by their code of conduct or otherwise to make clear. The corresponding corollary to that we heard about in the previous hearing was if the victim chooses not to proceed and not to participate, then the university will not be proceeding without a victim of an alleged sexual assault. And so those are the changes from lines 51 through 55. The other addition, Mr. Chairman, is
that's a very important addition.
with regard to matters of privilege, and this is on lines 62 and 63.
Page 3.
We have added OCGA 24-2-502, which is the clergy and religious communication privilege, and also 24-5509, which is the sexual assault advocate privilege in that code section. And so those, frankly, that was my oversight in terms of that section not being included to begin with. And so after touring the health center at the University of Georgia and talking to my folks over there, I realized there was a privilege that I knew nothing about in the evidence code because it didn't come up in my practice every day. So that certainly is a very important privilege that was an oversight on my part, and we have added it. And so those are the changes, Mr. Chairman.
Right. Will you also speak to the basic change between individual and university reporting that's been inherent? Because that was a question, and that was your language, and you've clarified it.
Mr. Chairman, that was actually a change that the committee made from the first version of the bill to the first substitute that was voted out last time. And the notion being we did not want to create an individual reporting requirement, which the first draft of the bill did, which put a professor or a faculty member or staff person in a predicament of having to pick up the phone and call 911. But rather they can direct that student to the confidential reporters, the privileged communicators on campus, and then at that point it is the university's obligation and purview to develop whatever reporting requirements they want to have internally. We have purposefully tried to maximize the flexibility of the institutions to deal with how they handle their institutional mandatory reporting requirement.
So the testimony we heard were a favored professor with a trust level last time. would not be in a position as a duty to report. That professor could either do that or give them the ability to talk to the privileged communication.
Not from us, Mr. Chairman.
Not
That
from
will
us.
be up to each
That would be up to the
institution
institution.
to decide for itself.
We're not changing that.
Yes, sir.
Correct. Okay, members of the committee, questions? No. Representative Smyrie, I think you're 8.
Mr. Chairman and Representative Quick, yesterday when I kind of looked at where we were and to where we are now, the two concerns that the chairman and I have talked about, one was the mandatory reporting, and the other one was due process. Now, the due process, of course, is a wider discussion. So
one of the things I forgot to tell you, one of the things I want to suggest, I was going to say it at the end, so maybe I can get ahead of your question here. I'm going to, as the chairman of the subcommittee, put together a task force, because you're right, due process is a bigger issue. I want to get yourself and this committee together in a study committee and make recommendations due process university wide, and we'll come back next year with a solid recommendation on that.
All right. The other one was the mandatory reporting. We had offered up some discussion on yesterday as it relates to the mandatory reporting and giving the accused, the victim, an option of reporting. But under what I'm reading now, that they would have to directly go to law enforcement. Am I understanding that correctly? That if something if a crime or felony had been committed, that the victim at that time would not have a choice of what direction they would go in. Is that what?
No, I think it's the other. I think what we're trying to do is make sure that the victim has many avenues that are not necessarily mandatory reporting. We've said that very clearly the victim can choose to go to a confidential report, and then at that point there is no. It says that no investigation to participate on line 34, 35. Nothing shall require a victim to cooperate with law enforcement in any investigation. 36. Representative Quick, you want to?
Yes, sir, Mr. Chairman,
as well.
and Dean Smyrie, also, the clarification is on lines 27 through 29 of the substitute,
Oh, that's
where
right.
it makes clear that it's a non-identifying report unless the victim consents to the disclosure of identifying information.
Otherwise, it's just a clarity.
Yes, sir.
So the information can be provided to law enforcement without the victim's consent.
That is correct.
Is that correct?
The non-identifying information, just like Sheriff Berry had the report when he testified previously, and we sort of looked at the Clary Act notice. It notified him that there was an assault against a male student, alleged assault, and he picked up the phone and called and wanted to know what evidence there was that was being preserved, and did the victim want to prosecute, and they said no.
That's current federal Clary Act
Yes, sir.
practice, that it's non-identifying, so the victim in that case is not uncovered whatsoever.
It was not known to Sheriff
Was not
Berry
known.
at that time, and may not ever be known to
Right,
Sheriff
unless the
Berry.
victim themselves.
Mr. Chairman, and so what this language from 27 through 29 simply is restating that with clarity, that if the felony involves alleged sexual assault, no information which specifically identifies the victim shall be provided in the report without the consent of the victim. In other words, we're belt and suspenders, so to speak, clarifying what is already out there.
The goal was to leave no doubt that we were not trying to set up a direct contradiction with the federal law under the Clary Act. Yes, sir.
Representative Smyrie.
Go ahead.
Okay. Representative Chairman Sessler. I can come back to you too, Cal. Yeah.
Thank you, Mr. Chairman. I want to take off kind of where maybe the dean left off on the issue of due process. And again, there may be different issues around this committee. I've got concerns on the due process front and I wanted to put that before the Representative Quick and yourself. Lines 44 through 51, and I won't read the whole section, but however, no student shall be subject to any interim discipline, suspension, expulsion, or so forth, essentially from the actions that led to the investigation, without being provided the opportunity of a hearing affording due process protections. That's the first of a two-part question. Are we deeming that a hearing constitutes due process?
Chairman Setzler, I don't believe we're deeming that, but what we are doing is giving the universities leeway and flexibility to develop their own due process standards, which the chairman has, I think, just indicated that we will continue to look at to determine whether or not the process that is due is being provided.
Chairman Setzler had a couple amendments last time directly on that point, and just as Dean Smyrie has that same concern, I do as well, Chairman Setzler, and you and I have had significant discussions, and we're going to get to that. We really are, because that's a very important discussion to have.
And if it pleases the chair, I just want to follow up on that. I'm not. I mean, I don't want to come in a hostile posture today, just personally, but I mean, we've got testimony in the previous hearing that hearings were had, and the hearings were, in essence, a kangaroo court. There was no semblance of, and even the evidence that was presented was not obtained in a valid way, and the idea of anything that looked like a judicial or quasi-judicial hearing was just, it was a mockery of that. So the fact that we're saying have your hearing as hearings in essence have been done at the discretion of the institution or otherwise, that's been proven to fail time and again.
Here's the distinction. I understand.
Yeah.
I really do. And here's the distinction. Take a look at lines 56, 57, and 58. Because prior to the Dear Colleague letter in 2011, the universities, whether their due process protections were perfect or not, they had a fairly significant standard that had worked for a long time, clear and convincing evidence, and through any other types of felonies, that kind of thing.
Which I'm very friendly to that.
Yeah, you're very, but that still needs some work, and that's what Representative Smyrie is saying, that's what you're saying. But specifically to the issue of the testimony we heard with respect to these Title IX investigations and the special kangaroo courts, that type of thing, that changed the standard of due process based on a guidance letter. Because of this legislation, those guidance letters are no longer dispositive with respect to that. We will go back to pre-2011. Due process is the same across all felonies are created equal, all student conducts, and then we as a committee can get into the overall due process. That's the idea. But that is the determining differential in this piece of legislation. Beyond the fact that we're now going to take all those resources in those different courts and put them towards sexual assault prevention, law enforcement prevention,
Sure.
counseling on campuses.
Appreciate the chair's work on that. Mr. Chairman, can I ask one
Sure, certainly.
related question? On lines 50 through 51, relating to that investigation, no disciplinary investigation shall obstruct or prejudice an ongoing criminal investigation. I mean, we had testimony before that the standards by which evidence is collected, whether it's going into students' rooms and looking for stuff or otherwise, it's very, very broad. No disciplinary investigation shall obstruct or prejudice an ongoing criminal investigation. Is the effect of this, and I know it's not the intention, is the effect of this if an investigation happens, they collect evidence using procedures and methods that would otherwise invalidate it for introduction of evidence in a criminal case, are we saying that they can collect it in a non-criminally valid way and that it can then still be introduced in court? Or are we saying if it's, is the effect of this sentence, this seems to be a big sentence to me, if we're telling them they can collect it really however they want to, don't have to follow due process and rules of evidence from the standpoint of chain of custody and any of those things, are we saying that they can go do that? Because I think on the criminal side, if they collect evidence that way, important evidence that would be needed for a criminal prosecution, if that was valid, could be compromised because they're told by this clause here that they can collect it really however they want to and don't have to follow rules of evidence. I'm concerned well-minded actors trying to pursue an action against a violator is gonna mess up the evidence and make it not able to be introduced in court because we've told them here they can really collect it.
Actually, no, I read it differently.
Okay.
Chairman Sessler, it says no disciplinary investigation, i.e. the campus investigation, shall obstruct or prejudice an ongoing criminal investigation. In other words, the civil authorities, if it goes to an investigatory process, will be the lead in that. Universities, again, prior to 2011, universities had a long track record. If there's a felony committed on campus, unless it's their post-certified law enforcement who are doing the investigation, that's who was in charge of it, not the faculty or the campus investigatory process. This is saying clearly in my mind, no institution shall have a disciplinary investigation that obstructs that civil authority nor prejudice it in any way. So in other words, that says to the institution, let the civil authorities do their job, is the way I read that.
Okay.
And that's the intention.
I'm certainly a friend of that, Mr. Chairman.
Okay.
If that's the effect of this, that's great. I was just concerned.
No, I appreciate the concern.
Chairman Setzler, I think I understand your concern, and I think what Chairman Earhart has tried to do, I'll say this, and I'm serious, is to be restrained in much of his attempts to impress upon the institutions the seriousness of their obligations toward the administration of justice and campus safety, while at the same time leaving them flexibility to do what they need to do with this as a big yellow caution light.
Okay. Any other questions? All right, we'll move into some of the testimony. Thank you, Representative Quick. If you just stay here,
Yes, sir,
if you
Mr.
don't
Chair.
mind, please. All right. First up is, if you'll please remember the timelines, Lisa Anderson. If you'll take that microphone in that chair, please. And
Thank you, Mr. Chairperson.
hold on just a second, Miss let me get your microphone on. There you go. I think it should be live now. You can move it around.
Is that
We got you.
a good spot? Okay. First of all, thank you so much for allowing me to speak, and I just wanted to express my true admiration for your concern about due process. My name is Lisa Anderson. I'm the executive director and founder of Atlanta Women for Equality. We're a young nonprofit legal aid organization, and we provide free legal assistance to women and girls who've experienced sex discrimination in the workplace or educational environment. And we have specifically been focusing on campus sexual violence recently, because we're very small, so we have to allocate our resources very carefully. I became an attorney for one reason, and that was to start this organization. And that is my humble attempt to give back for what was given to me when I was raped when I was in graduate school. I am a very strong person, so I've been told. And but when I was raped, I got down on my knees and I begged him to give me a chance to accustom myself to the idea that I would have to provide him with sexual pleasure because he was demanding it. And it didn't work. I cried while I looked at the ceiling, and then I remember I caught, the image of a lamp that he called his F-me lamp, that was something that was fashioned to look like something a little girl would have. I did not want to report it immediately. I tried to blame myself. And then I found out that he had raped a number of other women before, and they had even given him an independent study with an undergraduate woman. So I reported him, and the investigation process was very difficult. And when I talked to law enforcement, and this was, going on 14 years ago, when I talked to law enforcement, they told me, well, it's too late to do a rape kit, and I would advise you not to report to the police because the investigation would automatically be public record and it will be very hard for you. I work with clients every day who have experienced sexual violence on campus, And I have been told by every single one that I'm currently working with that they would not report if they would be, if information would be given to law enforcement. I do truly appreciate that you specified that information that specifically identifies the victims would not be included with reports. However, if law enforcement is to determine whether or not to investigate, I would think that in order for that to work, you would have to include details that could lead to investigations, to identifying the victim as the person who was the subject of the crime. And in order to decide, I'm just not sure how that would work without enough information for the prosecutor to investigate. What I wanted to emphasize is that we are absolutely in opposition to this bill, but not because we want to disparage the importance of due process rights. And in fact, it's precisely for that reason that we are opposed to this bill, because as you all know, there are two very different systems that are involved. There's the criminal system, and then there is the university disciplinary process. The parties are different. In the criminal system, it's the state with resources that dwarf those of the individual against a private individual. And in order to balance the scales of justice, it's so important to have very specific procedural protections. In cases in university disciplinary hearings, they're two similarly situated individuals with equal interests at stake who come to the table on equal footing. And so the concept of due process is very different. And it's so important that we have two options, at least, there are a number of others, but the option both to report, to the state so they can pose the question of whether this, non-consensual sexual conduct occurred and it was an injury to the state. The question for university hearings is whether the conduct was of a sexual nature and so pervasive, severe, or persistent that it either denied or limited someone's access to educational programs and activities.
You're at about 6 minutes. So
Oh, sorry.
If you want to I'm trying to be.
No,
well,
I
trying to keep it under
understand.
5, but
So basically, and we have Title IX. Title IX provides many due process protections, and the cases that you've mentioned, it is absolutely unacceptable for anybody to be, subjected to inequitable treatment. And that's why we have, the Office for Civil Rights, Department of Education, and the courts. So basically, I truly admire your interest in looking out for the due process rights of your constituents. However, I respectfully disagree that this is the way to approach it. I also think it's not great for the respondents either, because you automatically get a criminal record if it's reported to the police. It's a time when you're looking for a job, maybe applying to graduate school, and investigations can take years. And even if you're ultimately found not guilty, it's still a matter of public record, and you have to get it expunged, and so it can hurt your, everything from your credit rating to your, to your job perspective. So, anyway, I
Okay.
truly appreciate it, and I
Thank you.
apologize for going over
and
time.
that's okay. I was trying to be respectful. Thank you, Ms.
I really
Henderson.
appreciate it. Thank you.
Ms. Haynes.
Good morning. My name is Michaela Haynes. I'm currently a student at Spelman College, and I'm also a survivor of sexual assault. My freshman year of college, I lost my virginity through non-consensual sex. As both an activist against sexual assault and a survivor, I realized that my school may have not gotten it right in the past, but today I do see the progress with survivors who are being listened to, believed, receiving counseling, providing of non-contact contracts, among other resources and accommodations. Everything is being done on the survivor's terms because it is now being seen as extremely important to put the survivor first at all times. Studies show that perpetrators of sexual violence are less likely to be incarcerated as compared to other violent crimes, with the national conviction rate of rape being 3% according to the Department of Justice. Many police officers are not properly trained on how to sensitively help victims of sexual violence, especially marginalized survivors such as people with disabilities, women of color, and LGBTQ folks. Also, Georgia's strict laws around rape would make it impossible for LGBT survivors to report their sexual assault. As someone who has dealt with depression, anger, and suicide attempts, I know for a fact that dealing with trauma is a process, and school accommodations is a necessity for student survivors to stay in school. Going straight to law enforcement is not something every survivor wants or needs in order to continue their education. Moreover, as a woman of color, I know factually that the justice system was not made for me, but rather it is built against me and other marginalized groups, such as the LGBTQ community and individuals with disabilities. Additionally, Title VI and Title II ensures equal access to education to students of color and people with disabilities. The Office of Civil Rights stated that sexual harassment, dating violence, stalking, and other forms of sexual violence hinders a student's access to education. If passed, HB 51 will also violate these federal laws and further marginalize survivors of color, survivors with disabilities, and LGBTQ survivors. I like to end my speech with a few questions we must ask ourselves if our shared goal is to ensure the safety of all students on college campuses. Why would survivors, especially those who are marginalized, have faith in law enforcement, an institution who are the so-called protectors of this nation and its people, and report an assault when history and statistics shows all of us that they've always failed our groups? I would like to recognize the fact that Representative Earl Earhart decided to write this bill when the parent of someone who was falsely accused contacted him. False reporting is less than 8% of sexual assault cases nationally. So why would our main focus be on passing a bill to help benefit that 8% rather than the larger portion of assaults that are actually true? Why are we violating federal laws in order to show bias towards perpetrators and make it easier for people to rape on campus with impunity? Why are we yet again taking away the autonomy of survivors? Why are we preventing survivors from obtaining an equal education? Survivors know when the time is right to come forward and speak. Survivors need to be protected. This bill will not keep campuses safe, but quite the opposite. It is not in the best interest of students or survivors. Thank you.
Thank you for your testimony. I've got a couple members of the committee who want to make a statement. I think we'll start Representative Fleming, and Chairman Knight, and Chairman Sessler. So,
I just had a question.
okay, we can get to those when we finish the testimony. You want to?
Well,
No, I'm good.
before
Okay.
I was gonna ask a quick question.
Okay, that's fine.
One question, one comment, but.
Ms. Hayes, yeah, I just heard a term that you just said that I've never heard of, a non-contact contract.
Yes.
What is that?
For Spelman and Morehouse, I'm not sure about other college campuses in the state of Georgia, but if you do report an assault and you don't want your perpetrator to come on campus, they do have non-contact contracts that students can have. Because Spelman is an all-women's institution, Morehouse is all men, so they're not allowed to come on campus.
Okay, Representative Fleming.
Ms. Haynes, you said in your statement, and I tried to write it down, that this would allow rape on campus with impunity.
Yes.
Please explain that.
If HB 51 passes, I feel like, for myself especially, survivors would not want to report their sexual assault, which may lead to perpetrators thinking that if they are not reporting, I can continue to do this and nothing will happen to me.
The previous witness said that she decided not to report long before we ever enacted this law. What specifically about enacting this law would make people not want to report?
If we're being forced or if we're being asked to talk to police officers and it's not on our terms, we will not want to report it.
Where in this bill are you forced to talk to a police officer?
From my knowledge of the bill, speaking a few weeks ago, it was stated that we would be forced to report to police officers.
So you're not aware of what's in the bill now?
No.
Thank you.
Chairman Sessler.
Thank you, Mr. Chairman. I can't say enough to apologize for what's happened to you. My heart broke when you opened your presentation. I just want to say that. I would say, though, talking about disenfranchising people, minority and minorities and people of specifically, as you referred to, disenfranchised individuals, our criminal justice system protects the rights of the one against the prerogatives of the majority. You could have an entire room full of people against you, and if you yourself as an individual don't have rights protected through due process, and that's the very nature of rights, is protect the minority and disenfranchise people or the individual from the prerogatives and really the power of the majority. That's why rights exist. We're doing this to address exactly what you're advocating for, is protect the one versus the prerogatives of the many. That's what this is all about. The narrative that Chairman Earhart and Representative Quick are using this as some the implications that this is not supporting people's rights is a 180-degree miss from when we do things like this. We're protecting the one versus the prerogatives of the many. We're protecting the disenfranchised person because sometimes the majority is against them. That's what rights are all about. I just wanted to make that very, very important point. I appreciate you coming here. I treasure the fact you would come here and speak to us today. And I'm not saying that as a throwaway comment. But the whole purpose of rights is that when you've done something that's not popular and there's a whole array of people against you, your rights exist if you stand alone. That's why due process and putting these things in place is so important. Okay, Mr. Chairman.
Your Honors, if I might, oh, sorry.
Hold on. Let's, we've got other people to testify, so thank you, Ms. Haynes.
Thank you.
Oh, you have a question, sir?
Very respectful there. I mean, student in college. And I think your testimony stands for itself, and I think we'll let that be it.
Thank you for your time.
Thank you.
Okay. Okay. Mr. Charles Jones.
Thank you, Mr. Chairman and friends, and Dean Smyrie for the Minority Party. Thank you for making time for me today. My name is Charles Jones, and I've volunteered for a number of years now with an organization called Families Advocating for Campus Equality. And we are an organization founded by mothers of young men who have been falsely accused and have gone through the kangaroo court of the campus judiciary process. And the reason I'm supporting this bill is because I think it's very important to keep these young men out of this ridiculous system in which they really have no rights whatsoever. You know, I heard a couple of minutes ago that we need to focus on the survivor at all times. Well, according to a federal judge who has validated a lawsuit against Brandeis University on this very issue of due process, he pointed it out very well. He said that whether someone is a victim or a survivor or a rapist is not something to be presumed right away. It is something to be only determined after a full and fair hearing. And I think that's very important. I'm very happy that Chairman Setzler is working on those due process protections. Personally, I would like to see that. I would like to see inclusion of proof instead of by a preponderance of the evidence, proof by clear and convincing evidence, given the seriousness of this. You know, I've heard, and many of you may have heard, I know a lot of emails and letters are going around, heard that false accusations of rape and sexual assault are only, 2%? Someone said 8% a while ago. Nothing could be further from the truth. In fact, false accusations, according to the only peer-reviewed study that's out there, are 40%. 40% of the accusations are false. And I'll be glad.
Please conduct yourself as adults.
And I'll be glad to render a citation for the committee in writing if you prefer, or I can drop it by your offices. So it's very important to understand that these young men who are falsely accused are in this system. You know, this is probably going to generate some controversy too, but I don't mind saying it because I know these young men and I know their mothers. And I'll tell you that the trauma of going through a false accusation in this campus kangaroo court process is not unlike the trauma that someone experiences when they're raped. And it is. Yeah.
I'm going to ask you to pause. Ladies and
Okay.
gentlemen, I'm not one of those committee chairmen who are that patient with those who cannot have an adult conversation. If the courtesy that was shown to the first two people who testified will be shown to this one. Regardless of your position, I will ask you to leave if you cannot conduct yourselves in a manner that shows respect. You get one warning. This is a macro-aggressive environment. If you feel triggered, trigger somewhere else. Continue.
Thank you, Mr. Chairman. I'd like to read just a portion. I won't read this out loud, but a letter from a mother. And she writes, "The impact of the 16-month nightmare has forever changed my son and our family. They've spent nearly $320,000 in legal expenses, doctors, and medication. Her son in particular is one of that portion of the population for which anti-anxiety and antidepressant medicines have no effect. So he's dealing with post-traumatic stress disorder as the result of this. And he actually attempted to start his college career over, transferred here to Georgia to a small school in Athens in Representative Quick's district. And the post-traumatic stress that he had experienced was severely too much for him, and he wasn't even able to do that. We've seen people who have, in their areas, been cleared by the grand juries, been cleared by prosecutors, and the colleges still expel them. And the stories of this abound. These are not rare incidents. There was
You're
just
running up on your 5 minutes too, Mr. Jones.
Sure,
Please
I'll just be very
wrap
quick.
it up. Thank you.
I'll share this with the committee members personally or by your offices. These are not rare incidents, and we need to keep these young men out of this process and into the system where they have rights to. Those are my remarks. Have I any questions from the committee?
I don't see any. Thank you very much.
Thank you. May I be excused?
Yes, you can. Okay, ladies and gentlemen, members of the committee, what's your pleasure?
Move to pass.
I have a motion to pass. Is there a second?
Second.
Oh, I'm sorry, Representative Smiley.
Mr. Chairman, before we vote, I just want to express to you,
Certainly.
I've worked with you and Representative Quick over many years, especially you, on many, many years, and I have the most admiration and respect for you. And of course, you know, my position is we've been working together,
Yes, ma'am.
and I like to continue that.
We'll continue
spirit
that
of
all the way
esprit
through.
de corps, but I like to reserve my right as a member of this committee for future consideration as it relates to the bill. I want to continue to work with you, and I've heard testimony from both sides, and there's some areas in here that I think we have some flex on, and I really want a happy medium. I really want due process and have the victim and the accused to have a sensible, reasonable due process as it relates to a person being accused and then a person being a victim. But my heart is torn when I hear the testimony of persons, and it appears that the system does not equate or does not fit the process of protecting them in the fact that they have been maliciously or raped in the terms of a felony. And so I want to continue to work with you. You have been very, very receptive to me, and that I'm appreciative. You spent time and time with me on this issue. And yesterday I had the chance for the first time to sit down with Representative Quick and have a conversation. And I've always knew of her learned position on family law and working in that arena as an attorney. And I'm not an attorney, but I have an attorney that's with me at all times, especially on the bill of this magnitude and this nature. So I'm going to take it to the next process, but at the same time, I reserve the right to go back to my caucus, who I represent, and inform them where we are and in terms of from the original bill now to the sub, because when we talked on yesterday, we had several items that I wanted to that I wanted to get in the bill, and the interim measures was one, and the and defined it as used in the code section, and then the other one was dealing with the mandatory reporting and the process thereof. So I'm going to be talking with because there's a reason I'm here, and there's a reason that I've been meeting with you for all the times that we met and Representative Quick, and I don't want to abandon the position of the people that I represent. In light of that, I've been asked to assist in this process of trying to come, and I've been doing that for a long time, trying to be in a position where we can come to a point of having some sensible, reasonable agreement. So
Thank you so
that's where
much.
I am.
Thank you so much,
Okay.
Chair. I'm going to call you Chairman Smart. That's how I knew you. You and I have worked together for over 30 years, and you're one of the most collaborative, most genuine people I've ever had the pleasure to work with down here. And we shared a job that few people shared as Rules Chair for many years. When you sat here, you showed me that respect, and you have my word. We will continue this process, take the ideas that we have been collaboratively talking about and put them together. There's a lot of process left to go. This is just the House side of the equation, and then conference committees and everything else. And you and I have worked together on issues back to the Harris administration. So we know how to get this done together and collaboratively, and that will be the process, and that's how we'll do it. All right, members of the committee, I see a couple questions still. Chairman Sessler and then Representative Fleming.
Mr. Chairman, I'd like to thank you and Representative Quick for the what I see as a real attempt to try to bring this and listen to the concerns of both sides. I stayed for an hour and a half after the last hearing talking to victims advocates to try to hear this, and I would just say to people that are here, this is our heart breaks for victims, our heart breaks for people that are wrongly. I think everybody in here who cares about the one victim who feels very alone in this ought to feel I'd have great concern for one person that's wrongly accused. I think we care about both sides of this, that people are treated fairly and rightly. And I think we all can honestly say that. And I would just encourage folks who don't spend a lot of time in this Capitol, thanks for being here. This is not a for and against issue. This is not a polarized black and white issue. This is an issue of trying to strike the right balance to protect every single person. Because if the single individual doesn't matter, the victim, the falsely accused, if the single person doesn't matter, no one matters. And this is about preserving the lone person wherever they stand in this divide, and I appreciate your attempt to try to do that.
Thank you, Chairman Sessler. Representative Fleming. You good? All right, we have a motion and a second. All those in favor signify by saying aye. Aye. Opposed? Motion passes. Moves to full committee. Thank you very much. Thank you, ladies and gentlemen.